All right. Good afternoon, everyone. As promised, this is day one of the Douglas and Runger Estate Planning Mini Boot Camp. I have to give you a full disclosure here. I had actually prepared some PowerPoint slides for each of these three little mini sessions. And when I was trying to coordinate them and share my screen on Facebook Live, I just can't stand the screen sharing platform on Facebook Live. I think it's terrible. The screen wasn't showing up very well. The documents weren't showing up very well. So what I decided to do is to basically just run through these 3 days and do the training here live. And then what I will do is later in the week, I'm actually going to put something together that's basically like a summary of all this stuff. And I'm going to record it on Zoom and I'm going to post it in the group. And so that will be a nice actual PowerPoint presentation with me talking over it. It will hit all the high points for you. And then we will have some pricing options for you if you're interested in taking advantage of any of these documents. But for those of you who do not know me, my name is Kurt Runger, and I am the managing attorney at Douglas and Runger, which is a law firm in Memphis, Tennessee. And a big part of our practice is helping individuals navigate through the estate planning and probate process. And so the other day, I was thinking about just the current state of where we are right now and how it's crazy and everybody is locked down at home, and you just are constantly being inundated with news about everybody who is getting sick, and the number of coronavirus cases keep rising, and the more and more people keep passing away every day. And so I realized that it had piqued a lot of people's interest in estate planning documents. And so I wanted to put this thing together and just give everybody a basic rundown of what would constitute a basic estate planning package. So there's really 4 documents which constitute your basic estate planning package. And the first document is the one that we're going to talk about today, and that is a last will and testament, okay? Not a living will, not to be confused with a living will. This is a last will and testament. So this is the legal document that an individual executes during their lifetime that designates how they want their property to pass upon their death, okay? Now, it's pretty straightforward. It's how do you want your property to be disposed of? Who do you want your property to go to? Now, I will say this. We are only talking about property that would constitute a probate estate. So, and this is very, very important, so I want you to listen up here. And if you have any questions, you can actually type them in the box. But when we're talking about property that gets disposed of via a last will and testament, we're talking about property that is titled in the name of an individual only. So what would be included to that would be a bank account in an individual's name. So Kurt Runger checking account, Kurt Runger savings account. We're not talking about joint accounts, Kurt Runger and Jody Runger. That is a joint account. So if I pass away upon my death, that Kurt Runger and Jody Runger bank account passes upon my death to the joint account holder. It would be the same as if I had a checking or a savings account that had a payable on death beneficiary on there. So we're only talking about assets that are titled in an individual's names only. It's the same thing with retirement accounts. It's the same thing with stocks, IRAs, 401ks, life insurance policies. Assets such as those, which enable you to designate a named beneficiary upon your death, those are not disposed of via a last will and testament. those assets pass upon death to the named beneficiary. So, very, very important thing to understand at the get-go. When we're talking about a last will and testament, we're only dealing with assets that are in your name only. So you may actually think that you do a will and you want to say, okay, I'll leave my life insurance policy to my sister. Well, that's fine and good, but if the named beneficiary on your life insurance policy is your kid, it doesn't matter what's in your will. What's in the actual policy is going to control. So, last will and testament, we're dealing with how your property that's titled in your name only is going to be disposed of upon your death. The other thing that is big about the last will and testament is that in that document, an individual names what's called an executor if we're dealing with a male, or an executrix if we're dealing with a female. And the executor or the executrix is the individual that a person names in their last will and testament to essentially be in charge of wrapping up all of that person's affairs when they die. So, the executor or the executrix gathers up all of the important papers of a deceased person. They start going through documents. They locate the original last will and testament. And then, if they're smart, the first thing they do is reach out to the attorney, probably the attorney who actually drafted the will, if you've got that information, or just an attorney who could review the will and then begin to walk you through the process. So, other considerations about a last will and testament. This is something that actually drives me nuts because I hear people say this all the time. When we're dealing with just the process of getting a will, it is not just the document preparation that we're dealing with here. The document preparation is one part of it. All right, the other thing that is important, most important, is the lawful execution of the last will and testament. So for you people who think that I'm just going to go on LegalZoom and pay $150 and I'm going to get this last will and testament, or there's no reason for me to go to an attorney, let me just print one off the internet and sign it and I'll be good to go. That is absolutely 100% false, and it's a huge mistake that you're making, because it is well and true that you can go on LegalZoom and purchase a document that would meet the criteria for a valid last will and testament in Tennessee. That is factual. That being said, that's all you get. All right, the document has to be executed pursuant to our requirements of Tennessee law, and so yeah, great, you have a document that you ordered online or that you paid for online, but the will, in order to be valid in Tennessee, it has to be witnessed by two individuals who are not going to take under the terms of the will, and it also has to be notarized by a notary public. So you're going to have to be able to do that somewhere. I mean, I don't know what people who actually pull this thing off successfully by going on LegalZoom do. Maybe they're savvy enough and they go to the bank and they know that their banker has a notary public there and they can have two people, serve as witnesses. But it's so much easier to just go to a lawyer and get it done, because it's not that expensive of a process. Okay, so when we're talking about making a decision as to whether or not you want to try to do this on your own or order it online or go to a lawyer, just go to the lawyer, because the document preparation is just part of what you're paying for. You are paying for the lawful execution of the document. And the reason that it's great to go to lawyers, hey, if something happens and the original will is lost, we retain a copy of it. And so if I prepare a will for somebody and the person whose family member, the person who passes away, the family member can't find the will, I just have to go through, pull a copy of it, and then I know who my witnesses are. So the witnesses to the will are my legal assistants, and I could be a notary public, or another lawyer in the office could be a notary public. So that is an important consideration to keep in mind. Other things when we're dealing with a last will and testament. So you can disinherit basically anybody that you want. You do not have to leave property to your children. You can disinherit children. The only person that you cannot effectively disinherit in a will is a surviving spouse. So To give you an example, let's say that this you and your spouse were on the rocks before any of this coronavirus stuff was going on, and this is just what put you over the edge, and you can't stand them, and you want to do a new will. You had an old will that basically left everything to your wife, but now you want to change it, and not only do you want to change it, you're going to file for divorce. So even if you file for divorce and you execute a new will, if you are still legally married at the time that you die, all right, and the divorce has not been finalized, you cannot disinherit your surviving spouse. If you have been separated for a period of time from your spouse and you die and you have a will that doesn't have a provision for her, it does not matter. You're not going to be able to disinherit effectively somebody who you are legally married to at the time that you die. And the reason why is, and I'm not going to go into too much detail, but there are statutory protections in Tennessee that are afforded to surviving spouses that allow them to elect against the terms of a will. So you can disinherit whoever you want, you can leave stuff to whoever you want, but you're not going to be able to totally screw over or disinherit a wife. Typically, when we prepare last will and testaments, one question that we get is, where are these things recorded? Is there some sort of a universal database where my last will and testament is recorded? And the answer to that is no. Okay, we typically, and I say typically, 99% of the time, the individual who executes the last will and testament is going to leave our office with the original, and we are going to tell that individual, you guard this last will and testament with your life, because it's incredibly important that the loved ones, that the executor or the executrix be able to find the original will if you have to go to probate on it. It's difficult to, it's not impossible, but it's trickier to try to probate a copy of a will as a lost document, and so you really want the original. And so most of the time, these people who execute wills, they're going to take the original with them, and they're either going to put it in a safety deposit box at their bank, or they're going to have it in a fireproof box. And typically what we advise people to do is just let your loved ones know, like let your personal representative who you've named, your executor who you've named, know where that document is at your house, so that they'll know where to get it when you die. Okay. Last will and testaments, they can be simple as they need to be, or they can be as complex as you want it to be. So a simple will would essentially be, I leave all of my property, including all of my vehicles, my house in Memphis, Tennessee, my Air Jordans, my bank accounts, to my wife, Jody Runger, if she survives me. If my wife does not survive me, then I leave all of my property, including my bank accounts, my house in Memphis, and my Air Jordans, to my friends, Adam Exelbeard and Marcus Moss. That it could be as simple as that, or it could be complex. So some people want to leave property to individuals who are minors at the time when they execute their will, and so sometimes you'll have people who want to create what's called testamentary trusts inside of a will. So they will basically leave their property to somebody else, but they'll leave it to them in trust, and they will have certain provisions and certain restrictions in their last will and testament that dictate when the beneficiary is able to receive the property that's left to them. You can also, if you've got minor children, you are allowed to name a testamentary guardian for your minor children. So a lot of married couples do this. We have what's called a common disaster provision in our last will and testaments, which is basically if husband and wife come to us and they do a will, we have a provision in there that says if we die in a common disaster, that it should be presumed that I survived my wife or that my wife survived me. And in situations like that where you've got, and it's horrific, but it happens from time to time, where you've got a couple who die in a common disaster and they've got minor children. So what a lot of people like to do is actually put name a testamentary guardian for their minor children in their last will and testament. So we can do it as simple or as complicated as you want to do. Now, I've already talked about some of the pitfalls. Some of the pitfalls would be purchasing your will online. Trying to draft your own will, and the negative consequences of the pitfalls are grave. So in Tennessee, if you actually die and you have a valid will, you have a will that meets all the criteria of a valid will in Tennessee law, that's great. The executor, files a petition in probate court. They open up an estate. The will is presented to the probate court judge. The probate court judge verifies that everything in the will is valid, and then that's what's referred to as admitting the will to probate. So that's great. Then if that's the case, you've got a valid will and your estate is distributed pursuant to the terms of the will. That being said, if you try to probate a will that was purchased online or written out and it wasn't done correctly and the court rejects it then as not being a valid will, then your property is not going to be distributed how you want it to be distributed to. It will fall back to being distributed pursuant to what's called our laws of intestate succession. So intestate succession is when somebody dies without a valid will. And when that happens, the property that they have is going to go to their heirs at law. That could be a big deal because let's say that you are a widowed. Let's say that you're widowed, and so you're not married at the time that you pass away, and you've got 3 kids, and 2 of them have been miserable people who you just had a huge falling out with, and you have a good relationship with the other one. So let's say you want to do a will, and in that will you leave all your property to your best friend and to your child that you have a good relationship with. And then you include in there a provision that says your other 2 kids who are bums who you don't like, they don't get anything. Well, if the will doesn't meet the qualifications of a valid will and the probate court rejects it, guess what? Guess who your property is going to? It's going to your 2 kids who you hate and the 1 kid that you have a good relationship with. So the consequences of having a will that is not done properly can be disastrous. And it's really upsetting when we come across it in our practice because we're usually dealing with the person who knows, it's like, hey, my mother did not want this to happen to her property. Or, my dad, there is no way that he would have wanted so-and-so to get anything. But, it's a pitfall. That's a consequence of trying to cut corners. That's a consequence. It's a foreseeable consequence of trying to cut corners, and it's something that it can easily be avoided. So when we're talking about our basic estate planning documents, the most important one in the first part of this boot camp was the last will and testament. So tomorrow I will be back at 12 noon, and we will talk about the second 2 mainstay documents in a basic estate plan package, which are the power of attorney for healthcare and the durable power of attorney for business transactions. If you have any questions, please, as always, feel free to comment in the box below, PM me on Facebook, or send me an email at Kurt, C-U-R-T, at douglasrunger.com, and I will be happy to review them for you. And like I said, I apologize. I wanted to do this. I wanted to have a PowerPoint presentation on the screen, but I just don't like the Facebook. For those of you who may have showed up late, I just do not like the Facebook screen sharing platform. So what I'm going to do is I'm going to go back. I'm going to summarize all this stuff. I'm going to do a nice, neat, and tidy Zoom presentation. I'm going to post it up on this Douglas and Runger fan page later this week. All right. I hope everybody has a great rest of the afternoon and a great day, and I will see you tomorrow.